is a death or divorce situation, what to do, and what planning situations you have from a legal standpoint, a financial standpoint, and a few other areas. So just to give you a little background, my name is Jonathan Goldberg. I am an attorney with the firm Bloom Associates. I'm also one of the financial advisors at Bloom Advisors. And also in my spare time, I'm a CPA, but it all goes together. So I deal with a lot of our estate planning clients in the office in situations when there is a divorce or a death situation in administration after one passes. So I'm quite familiar with this area. As Karen said, if you have questions, feel free to type those in the chat area, and definitely we'll get those answered at the end of the presentation. So what we're going to discuss today are three different scenarios. One being a death situation. If a spouse or partner passes away, what you need to do. The other situation is if there is a divorce, what then occurs at that point. And in either situation, either upon a death or a divorce, once you are on your own, what things you need to do and plan for as that now becomes a new situation for yourself. Related to those situations would be various financial matters that you have to deal with. Again, there are always legal issues. And then, as I stated, I'm more than happy to answer your questions and try to give you answers to those specific questions that you may have. So to start, the first situation is when there is a death upon a individual. Either it may be a spouse or if you're a child, it may be the second parent, and what to do at that point. So the first thing that we always take into consideration, and again, this is starting to become income tax season in effect, is what are the impacts for income taxes? And just in general, at this time of the year, it's the first part of the year, it's always a good idea to get your income tax situation as much as you can in order, but it also makes sense from an estate planning standpoint to make certain that things are done. If there has been a death or a divorce, as I will describe in the presentation, certain things have been done as far as maybe changing your estate plan, either upon a death or a divorce, changing beneficiaries. Potentially, you may not want a former spouse to receive some of your assets. So just getting back to the income tax area, when there is a death, you have several options on how to file your income tax returns. Generally, in the year of death of a spouse or partner, if you're married, you are able to file that return as a married filed joint return. And in a lot of cases, that may result in a better tax situation than if you were just filing on a single status. So as the note says, you can file a joint return in the year that the spouse died. Generally, in most cases, but not in every situation, that surviving spouse is generally what we call the executor, the person who oversees the matters when a person passes away. We'll get into, in some cases, sometimes there is a probate. In other cases, there's not a probate. And if there is a will or trust, typically that person is what we call the executor. So under the trust, it may be a trustee. Under the will, it's a personal representative. But that person can file that tax return generally for the deceased and is responsible for getting that filed, paying any taxes, so that is properly done. If one were to remarry after that spouse passed away before the year end, then you have to take a look at that situation and potentially file a joint return with that new spouse, or potentially, as the next bullet point says, married filing separately. And married filing separately means at the end of the year, and you look at the December 31 of what your situation is, if you are married or single. And in that case, you take a look, and it may make sense in some cases to file married filing separately. Potentially, there could be a tax benefit for doing that for one of the spouses. In many cases, we recommend in those situations to file married filing separately, potentially if one of the individuals may have some debt or tax issues and there may be a refund coming. That person who is, let's say the spouse is receiving a refund, you would not want that to go to the IRS if it wasn't related to that specific individual. So there are certain circumstances, there could be tax purposes or liability purposes, why a husband and wife or couple file married filing separately. And generally, if you prepare your tax return on your own or you have a tax professional, they can run those numbers, which would result in the best tax situation. But as I said, taxes are not the only situation. There may be tax debts or other liabilities of why one files separately as opposed to married filing jointly. A couple other ways you can file your income tax returns after a death of a spouse. In certain circumstances, generally, if there's a dependent child, you may be able to file what's called qualifying widower, where you get a couple extra years of benefit after the death of the spouse. And again, the purpose of that is to file married filing jointly, which generally would result in less taxes to you. So that is beneficial. Another option, which in certain circumstances may result, again, either under a death situation or a divorce situation, is head of household. So again, if there is let's say dependent child, you can file as a head of household. Generally, that would result in a better tax situation as far as less taxes being owed on your income compared to, let's say, if one were filing as a single person. So again, generally, if you're doing the tax return on your own, or if you have a tax professional, that tax professional can help determine what would be the best status and what you're eligible to file as, because that's the first requirement. What are you eligible to file, the tax status, and then what, based on that tax status, what would be the best result for you. There's some other matters that need to be reviewed as far as once there is a death. So when there is a passing of a parent or a spouse, the first thing that you want to do is get organized and determine what assets did the deceased have. You generally don't want anything to fall through the cracks. You want to look at all the assets. One of the things I always tell clients to look into would be to search on the internet. Specifically, if you're a Michigan resident, you can go to Michigan unclaimed property, and you can type in a person's name, social security number, and you can see if the state is holding any assets for that deceased person. And I always tell clients it makes sense just to review it, just not for the deceased person, but for yourself, and to see if there is anything there or just a windfall. So that would be the first thing, would be to check with Michigan unclaimed property. You also want to make certain that you have a list of all the assets that the deceased owned. So as far as bank accounts, brokerage accounts, real estate, any business interests, limited liability companies, S corporations, if there are any retirement accounts, any annuities, any life insurance. A lot of people forget about savings bonds. So any type of asset that the deceased person owned, you want to make a list of that asset, and so that you can determine how to obtain that. The other purpose of that then is, how was that specific asset owned? And the purpose for doing that is, was it owned jointly, maybe with a surviving spouse? And if it was owned jointly with a surviving spouse or a child, then by law, it does not have to be probated. It goes to that other owner on that asset, and probate is avoided. However, if an asset is owned in an individual's name and that person dies, we'll get into, but there may need to be a probate, and we'll get into that in a few moments. So the other purpose also is, for income tax purposes, is what was the value as the date of death. So typically what happens is what we call as a step up in basis. So for example, if the deceased purchased a stock years and years ago, let's just say at $1 a share, And when that person passed away, let's just say it was worth $100, it now takes that stepped up basis, the date of death value of $100. So whatever that prior gain was goes away. The purpose of that is that that gain now disappears, and you as the survivor or potentially a trust takes that date of death value, and then assume it was worth $100 at the date of death. If you then sold it at some point thereafter, the basis is at 100, and whatever you sell it for would either be the difference between a gain or a loss. So that gain over time goes away. So that's really the first thing to do, is to determine what assets the deceased person owned, how was that asset owned, or did it have a beneficiary, and what was the date of death value, and that is really for an income tax purpose. There's also another purpose from an estate tax standpoint, is currently in this year, if one's assets exceed a threshold, they may have to file an estate tax return, which is due within 9 months of the date of death. And again, depending on the circumstances, they may have to pay an estate tax, which is really a death tax. So that threshold this year is per person is $12,920,000. So if one's assets are below that, there is no estate tax. There is no Michigan estate tax. If one has assets in another state, potentially let's say real estate, it's possible that that state may have their own estate tax, and it's possible that real estate could be taxed under that specific state's tax laws. So potentially an individual has an estate tax exemption of $12,920,000. If there was a married couple together, that threshold would be $25,840,000. So potentially assets can be avoided, but it just depends on also how those assets are owned and what type of assets there are. But the main thrust is that that threshold is $12,920,000 per person. When there's a death, one of the first things you should recognize is, did the deceased person receive a pension? And if so, you need to reach out to that company or those companies where the deceased was receiving a pension and to notify them that that person passed away. They typically will send you some paperwork. Potentially, you will need to find out what that pension amount you may then be receiving. It may be a lesser amount of what the deceased was receiving. And in some cases, potentially that pension amount may be zero. It just depends on what that individual selected when they were receiving that pension. So you definitely want to reach out to the pension company to inform them that there was a passing and find out what your new pension amount may be. Related to that is Social Security. Assuming that individual was receiving Social Security when they passed away, generally the funeral home will notify Social Security so that those future payments will then stop. It doesn't always happen, so you want to make certain that you do reach out to Social Security either yourself or confirm with the funeral home that they did reach out to Social Security so that those amounts will stop being paid. The other thing under Social Security, as a survivor, surviving spouse, you then may be able to receive, obviously, your own benefit, whatever, assuming if you had worked and earned credits. You may also be able to receive your spouse's retirement benefit. So again, you'll need to reach out to Social Security, find out what's the most advantageous course of action for yourself, as far as if you receive your own amounts or if you're receiving your deceased spouse's benefit amount. Another important thing that a lot of people fail to do when there's a death is to update beneficiaries. So for example, if you have a 401k plan through work, a retirement plan through work, or you have an IRA, it's always a good idea at this time of the year to confirm who your beneficiaries are. And in some cases, I've seen clients don't name anybody. And so what that would mean, again, if that individual passed away and there was not a beneficiary listed, it would need to be probated. So from that standpoint, You want to confirm on retirement accounts, on IRAs, as well as life insurance, who the beneficiary is that you have listed. Generally with retirement accounts and IRAs, in most cases, you're naming a spouse. And then as far as a secondary beneficiary, you may be naming children directly. You may be naming your revocable trust, and it just depends on the circumstances, ages of children, other factors related to the children, if you name them directly or if you name your revocable trust. Again, with a death situation, as I stated, the estate tax exemption amount this year per person is $12,920,000. And a lot of clients say, well, I am under that threshold. I don't have an estate tax situation currently or anything like that. However, the way the law is worded as of right now is that in 2026, that exemption amount, which is about close to 13 million, goes down to about $6 million per person. And so again, what happens is the IRS says, what is the value of everything you own? And that includes any type of life insurance. So most people don't recognize, well, that's an asset from an estate tax standpoint, but it is. So if you have significant life insurance and other assets, those all get combined to go to that threshold, whatever that may be in the year. But as I said, in 2026, the exemption is approximately $6 million and per person, and that could result potentially in an estate tax situation for you at that time. Again, just depends on the value of your assets and what that exemption amount is at that time. As I mentioned, probate, one of the things I always tell clients you want to avoid is probate. As an attorney, I see clients very frustrated. It's generally not a very quick process. It's an expensive process. It's a public process, which frequently when I file a probate, I frequently receive letters from companies trying to say, well, I want to help your client invest. I want to purchase the real estate. So a lot of people do look at the probate filings and in some cases try to negatively impact or affect individuals or surviving spouses. So what probate is when an asset is owned by a deceased person and that asset is in their name alone, at that point, no one has authority over that asset. And what probate is, various forms are filed with the probate court in the county where the individual resided, and authority then is granted to what's called the personal representative. Now, if a person has a will, generally that will states who that personal representative is. So usually it's a spouse. It may then be children or one or more children acting together. So that personal representative is responsible for filing that probate forms and then dealing with the probate process, contacting wherever that asset is, having it transferred, dealing with then potentially selling that asset and distributing it according to the will if there is a will, or if there's not a will, transferring it under what we call the intestate laws, which means there is no will, and there's certain requirements then if a certain amount is going to a spouse and then children. So that is what we call the regular probate process. If one passed away and had total assets that were in the deceased name alone, less than $25,000, then there's a small estate process. It's pretty quick. It's a 2-page form. Certain information needs to be submitted to the probate court, and it's a pretty simple process to do. The regular probate process is more involved. Typically, I tell clients a fast probate is usually about a 6-month time frame, and it could even be longer. It just depends on what the assets are and what's involved in that. Typically, I'll tell clients on average, it just depends, but usually I'll say between 6 to 12 months for the probate process for a regular probate to be completed from start to finish, to have all the assets transferred to the beneficiaries, and to make certain there is nothing left in that probate system. When you also have a death situation, you also have administration issues. So as I said, if there is a probate, you will also have to obtain a tax ID number for that probate, because at that point, those assets need to be in a new tax ID number, not in the deceased person's social security number. In addition, if one has a trust and assets are owned by the trust, when that person passes away, that trust now needs to get a new tax ID number as well. So under the circumstances, there may be the need to obtain a new tax ID number. Now, again, if assets were owned jointly, it goes to that survivor of that asset, and there would not be the need for a new tax ID number. So it really just depends under the circumstances. When there is a death, I always tell clients we do need to have an administration meeting. There may be certain things that need to be done at that point. And again, looking at the assets, there may need to be a probate. In some cases, there may be an estate tax return, again, if there are significant assets. When you do have a tax ID number for either a probate estate or the trust, there is then an income tax return for that probate estate or for that trust. And the tax form number is a Form 1041. It's similar to a Form 1040. As I stated, I am a CPA and I know how to prepare those forms and all of that, but it's not all that simple. And typically I tell clients, have a CPA who's experienced, who's knowledgeable, because it is a more complex return than doing your own personal return. So from that standpoint, a professional should be helping you with the Form 1041. A lot of cases, it usually has a calendar year basis, but not always. It just depends on the circumstances. But again, that's one of the things under the administration that we would assist with and try to make a determination of what's the best manner to do that. It's also required either through, if there is a probate, or if there is no probate and there is a trust, in either circumstance, there needs to be a publication notice. And that publication notice is different than, let's say, an obituary notice. The publication notice is filed in the county legal newspaper of where the individual resided, and it has to have certain information in that. So that's something we assist clients with. And from that standpoint, that is something that is required to be done. Basically, what it does is it tells creditors or potential creditors of the deceased, you have 4 months to make a claim against the estate or the trust if you have a claim and it's a valid claim. And then at that point, either the personal representative under the probate or the trustee under the trust makes a determination if that's a valid claim, and if so, pays it. If not, there's certain requirements that need to be filed with the court and with the potential creditor to say it's being disallowed. And then at that point, that creditor may then file a lawsuit to be paid what they think they're entitled to. As I mentioned, it's always a good idea, but specifically when one passes, for that surviving person to take a look at their own estate planning documents. In a lot of cases, documents have not been updated in numerous years. It may make sense to review who the successors are. If your children are now older and when you prepare documents, it's possible they were younger, you had someone else appointed as the successor. So it always makes sense to review who that would be. It also makes sense if you have minor children who are children below the age of 18, who the guardian would be. So let's say your spouse passed away, you now have minor children. It makes sense to say, who do you want to take care of your children when they're minors if you pass away? So again, you may have done that years ago. You may want to have someone who's different than what you currently have. Maybe you don't have a will at all or anyone appointed. And it would definitely make sense, again, if you have minor children. And typically what I tell clients would be, if you have minor children, that's the most important function, would be if both you and your spouse pass away, who would take care of your minor children? And you have to make that determination. As far as the rest of your estate planning, again, maybe you did documents a long time ago. You need to update who those successors are, either in the will, again, the personal representative who follows the will, the guardian, your successor trustee under your trust, but also for your medical care documents. Maybe you had someone else appointed, your children were younger, and now you want to appoint your children to be the successors. And the same is true for a durable power of attorney, which is dealing with financial decisions during your lifetime. It also makes sense to review any deeds that you have for any real estate that you own. Again, how was those deeds, how are they owned, in whose names, and in what manner? And that brings me to another area that we've done a lot of work on, is what we call a Ladybird deed. A Ladybird deed is a type of deed that says you own the property for your lifetime. So you can do anything you want with that property. You can sell it, you can finance it, anything you want to do. And at that point, when you pass away, assuming you still own that home, you're transferring it to a beneficiary. So if you have a trust, in many cases, we'll say transfer it to your revocable trust. If you don't have a trust, or potentially if you do, but you want a different result potentially, you would then specify a beneficiary or beneficiaries to receive that property. So the benefit is it avoids a probate. So that deed would get recorded shortly after it's signed. It gets filed in the county where the real estate is owned with the Register of Deeds. There's another document called a property transfer affidavit that gets filed with the city or township where the property is. So what happens is you still own the property, you control it, you do with it what you want. And as I said, upon death, it then goes to a beneficiary. The benefit of a Ladybird deed is, as I stated, it avoids a probate situation. It does not change your property taxes at all. And in those cases where if one's trying to do Medicaid planning, or one has to go into a nursing home and they qualify for Medicaid where they spend down their assets, by using this Ladybird deed, the home is an exempt asset. So in many cases, it used to be a deed was recorded and transferred into a trust. If one that was then trying to qualify for Medicaid, if the home is owned by the trust, it's no longer exempt for Medicaid purposes. So in some cases, we take it out of the trust, move it back to the individual, and then do a Ladybird deed to the trust. So it just depends under the circumstances. But the main benefit is it avoids a probate. You still control the property, you do with it what you want, and then you're stating upon your death where or which beneficiary you want to receive that property. And in a lot of cases, what I'll say more years ago, a lot of cases, attorneys would prepare what's called a quitclaim deed. It's a different type of deed. And they would say, when there's a death, record that deed at that point. Well, the problem I've run into is sometimes that deed can't be found. And then one or both individuals die, husband and wife die, and now the home needs to be probated. So by filing this deed, it avoids the Ladybird deed. By filing that now, that avoids any issue like that whatsoever. And we've been using this type of deed for years now, and it just avoids some potential issues. Again, if the deed can't be found, it got destroyed. If let's say the home caught on fire and that deed couldn't be found. So by doing this type of Ladybird deed, it's just the best of all worlds. A lot of times clients will say when there's a death, what's the time frame to administer those assets and to do these certain things that were discussed. And typically I tell clients, you don't want to do anything without speaking to an attorney. A lot of clients will go to a bank immediately. Generally, you don't want to do that. But usually within a few weeks, a month or so, you want to have that administration meeting, and then certain things can then be done at that point. The second situation under tonight's presentation is what happens when there's a divorce. And there's a lot of circumstances and matters that need to be determined. But one of the first things I always tell clients, once there's a divorce, it's been finalized, assets have been split, things of that sort, is you now need to update your estate planning documents. Generally, I would say in most cases, you're not going to want to name your former spouse as the successor trustee. You may not want them to make healthcare decisions, things like that. So at that point, it may be children, it may be friends or siblings who would now act as those successors. So typically, you're going to want to revise your estate plan, who those successors will be, how you want your assets to be distributed, and again, generally excluding that former spouse. It also makes sense to update your beneficiaries. So if you do have any type of life insurance, again, you would generally want to remove your former spouse. You would then either name your children as the beneficiaries or someone else, or if you do have a revocable trust, naming your revocable trust as the beneficiary. The same is also true with any type of retirement assets, 401k accounts, IRA accounts, things like that. You want to remove your former spouse, and you generally want to do this pretty quickly. That's one of the first things I would recommend in combination with updating your estate plan. But generally, this is something you can do very quickly after the divorce becomes finalized, is to update your beneficiary for life insurance, for retirement, 401k, and IRA accounts. And actually, there is case law out there that states if you have a retirement plan through your employer and you've named your spouse as the beneficiary, and now you die, and again, there was a divorce, and so there's a divorce, you then pass away, you never updated your beneficiary of your employer retirement plan, there are cases that say that former spouse gets that money. And in most cases, most people would say that's not what their wishes were. So it's pretty important to revise those beneficiaries fairly quickly after that divorce becomes finalized, so that your former spouse does not receive a windfall or assets of yours that you would not want that former spouse to receive. Again, when there's a divorce, you have to file a last income tax return as of December 31. So that status is based on that last day of the year. In some cases, a lot of cases, divorces don't become finalized until January. So as far as that prior year, again, from an income tax standpoint, it may make sense to file married filing jointly. But then the following year, let's say January is when the divorce became finalized, you would then very well have to file either as a single taxpayer or potentially a head of household if you have dependent children. So again, the key date is what was your marital status as of December 31. Once the divorce decree becomes finalized, what does the divorce decree say about splitting of assets? Who is to receive the home? So in a lot of cases, one of the individuals may receive the home. There needs to be a deed transferring the other person's interest to the other person who's remaining in the home. So a deed needs to be recorded, filed in the county, property transfer affidavit filed with the city or township. So at that point, that person who's living in the home is 100% owner on that property. As I said, the splitting of assets, if it's bank accounts, brokerage accounts, things of that would be under the divorce decree. And typically there would be a splitting on a certain date so that things then get split according to that divorce decree. And the same is true with retirement benefits or IRAs. Generally, again, under the divorce decree, that will specify how those assets are to be split. And again, generally you want to do that pretty quickly. So you receive your assets, you then have control over those assets, and then appoint whatever beneficiaries or move those into your trust or appoint beneficiaries so that if you were to pass away, potentially a probate could be avoided on those assets that are now in your name. When there's a divorce, at that point, there's also, it's when you apply for Social Security, you will then need to make a determination. So just as in a death situation, in the divorce situation, you can then determine to take your own Social Security benefits, assuming you were working. If you were not working or you earn less than your former spouse, you may be eligible to take a certain amount during those years of marriage from your former spouse. And the net result is you may receive a greater amount of Social Security benefits when you become eligible for Social Security. So you definitely want to plan for that as well, so that you can try to maximize what your Social Security benefits will be. So in the situation when there's been a death, or there's been a divorce, you are now on your own from a financial standpoint. And this may be a very brand new situation. In a lot of cases, I've seen, and that is definitely changing over the years, I've noticed. But in a lot of situations, the wife or former wife was not all that familiar with their financial situation. But as I said, more women have become more independent and are aware of their financial situation, either on their own or when they were married. So from that standpoint, you really need to determine what your goals and objectives are. So now you're on your own. You may be having adult children. You may have younger children, and your financial situation now changes because you no longer have dual income or income from a former spouse. You may be receiving alimony. You may be your own income or a combination. So the first thing to determine is, as a single individual at this point, what are your goals and objectives as far as for investing? And that needs to be determined. Are you saving for college? Are you saving for retirement? Are you looking to move into a new home or maybe downsize into a home? And if your home is sold, the equity in that. If you're looking to downsize, what to do with that excess money if you then move into a new home that's less expensive. So you first need to determine what your goals and objectives are. And that's something we always recommend to clients. What are your goals? What are you seeking to do? And in some cases, that's a fairly easy answer. In other cases where one never really had to deal with that, you really need to make that determination and find out what those goals and objectives are. The other important thing is, now that you're in a new situation, you need to understand and have a grasp of what your cash flow is. In effect, what are your income sources? If you're receiving Social Security or pension combination, if you're receiving alimony, if you're working, whatever those income sources are, you need to have a handle, an idea of what that amount will be. You then need to compare that to what are your monthly expenses, as far as if there's a rent or mortgage payment, insurance, property taxes, utilities, healthcare expenses, auto expenses, if you're saving money for college expenses, various things of that sort. So you need to compare those income sources to your expenses. And obviously, you want to be in a situation where your income is exceeding your expenses. So in some cases, you may need to revise what your expenses are. You may not be able to live as lavishly as you were when you were married, and potentially, or when your spouse was alive. So you may need to make some adjustments from what your cash flow situation was. And a lot of clients have a difficult time in trying to grasp, to really understand what their expenses are. And in a death situation or a divorce situation, it takes a period of time to really determine what those are. As I said, you really do have a sense as far as what your mortgage or rent payment is, potentially property taxes, homeowners insurance, car payments, various things like that. If you have your own life insurance, whatever that payment would be. So you really need to sit down and determine what those expenses are to give you the best situation and handle of what you can afford to do or not, what you can not do. The other thing to take a look into is, when you are investing, is what is your risk? Are you an aggressive investor? How should your portfolio be established? Are you more conservative? Are you moderate? So those things need to be determined. And again, this may be the very first time you've done that. You may want to take a look at your personal investments, your retirement accounts, your 401k through work, and really get a handle on how much risk you're willing to accept. So when we deal with clients, when we invest for them, we're really looking at what their goals and objectives are and what their risk tolerance is, not what my risk tolerance as their advisor, but what their risk tolerance is. And at that point, then a portfolio can then be determined based on what they're trying to achieve. And in some cases, again, if one has not dealt with their finances before, not really all that familiar with investing, then it may make sense to hire a professional to assist them to do that. And a lot of these items that we've discussed in this presentation would be something I would obtain from the client to find out specifics on what they're trying to achieve. Again, not what I'm trying to achieve for myself or what I think the client should achieve, but really listening to what they're trying to do. And that's the main aspect, is what are you as the client? What is your goal and objective? And how much risk are you willing to accept? In addition, it's a brand new world upon a passing. As far as if there's a death or a divorce situation, you're now responsible for filing your income tax returns. Again, in certain circumstances, it very well may make sense to have a professional do that for you. They can assist you with tax planning. Should you be increasing your contributions, let's say, into a 401k plan? If your employer has a health savings account, should that amount be utilized, or should you be maximizing that? So various factors can be used to determine what's the best situation from a tax planning standpoint. Just not the preparation of the return to say, here's the numbers, here's what your refund is or how much you owe, but ways you can also do planning. And that's a very important function of a tax return preparer or CPA, would be to assist you with that as well. And again, when you're looking at what tax planning you can do, you also have to compare that to what are your cash flow needs. So again, if you are currently this year, if you're over age 50, you can do a 401k contribution and catch up. The maximum you can put in is $30,000. Well, the question is, does that match what your cash flow situation is? And if it doesn't, then you may need to put in a lesser amount. So those things all need to be determined, and typically an advisor or CPA can assist you with that. The other important aspect is you are now on your own. Maybe your children are grown. You no longer have a spouse living with you. Do you still need as large of a home as you had before? A lot of clients downsize after a divorce or a death. They don't need that large of a home. Maybe the mortgage payment is not sufficient for them. Maybe the utilities and taxes and so on are greater than they can afford. So at that point, you also have to look into downsizing and potentially having something more economical for yourself, but also less upkeep as well. So that's a determination that needs to be made on a case-by-case basis. As Karen stated at the beginning, there is a checklist, and so you can take a look at that checklist as far as sort of the items we've discussed tonight to help you walk through that process as far as from a divorce situation. At this point, I'm going to answer any questions you have, but if you do have other questions or other needs, you can feel definitely free to reach out to me or take a look at our website for additional information. There's articles on there. There's other helpful information that you may find beneficial. So let me take a look at some of the questions that are in chat. And if you do have any other questions, feel free to ask away.
So it looks like there's one question in chat from Nancy. She wanted to know if you can do a Ladybird deed on an automobile.
A Ladybird deed is typically done with real estate. Okay, so a Ladybird deed would be filed with the county where that real estate is located. I've not heard of doing a Ladybird deed for an automobile. In some cases, you can do what's called or add a person as a joint tenants with rights of survivorship on the automobile. So that means if you die, that automobile would go to the survivor. Generally, though, it's not something I would recommend, because if let's say you're the primary driver on that automobile, and if you have inadequate insurance and that car is owned jointly, that creditor or that attorney for that potential creditor is going to go after that other person. So if you don't have appropriate auto insurance, that's not a good plan. In some cases, if you're trying to avoid a probate situation, again, if there is no probate whatsoever, so all your assets are owned, let's say jointly, or you have beneficiaries on those assets, or the assets are owned in a trust or a combination, so that if there is no probate, what can happen then is that personal representative, who very well may be the spouse or the children, can then take the certificate of title for the automobile to Secretary of State, and then that automobile can be transferred. So it can be transferred to that surviving spouse or a child or a grandchild of the deceased. So it just depends under the circumstances, really what you're trying to do. But in a great many cases, I don't recommend doing a automobile, as we say, joint tenants with rights of survivorship. There could be some liability purposes for that. So it just depends. But the answer to your question is, I'm not familiar with using a Ladybird deed. Again, that is only for real estate, not for an automobile. Okay. The next question was, if I did not receive a Quadro at the time of my divorce in 2000, am I too late? So what a Quadro is, it's called the QDRO, Qualified Domestic Relations Order. And typically it's dealing with either retirement monies, IRA or 401k or pension monies. And generally, it should have been addressed in the divorce decree at that point. So I guess the first question is, you'd have to take a look at your divorce decree to say, what are you entitled to, if anything, as far as any type of retirement benefits. And if you are, or if the divorce decree says, yes, you're supposed to get half the divorce or half of the retirement benefits for the years you were married, and that's never been filed, you're going to need to speak to a divorce attorney to have that prepared. And again, either if that's for your own retirement benefits, or if it's for a former spouse's where you're entitled to that, yes, you definitely want to get that filed so that you have legal rights to that. Because if not, it's potential that the prior or former spouse could utilize that money contrary to what the divorce decree stated. Somehow, if that's fallen through the cracks 22 years later, I would definitely say you want to get that updated and speak to a divorce attorney immediately, so that can get taken care of. Not sure if there's another question.
It looks like in the Q&A box, someone said, I have joint assets with a parent.
Okay.
I'm not sure if there's a follow-up question for that or just.
Okay, so it just really depends under the circumstances what that joint asset is. As far as, is it real estate? Is it a bank account, a brokerage account? Typically, I'm not a huge fan of adding a child to an asset. And there's a lot of reasons why. So the first reason is, if a parent adds a child, let's just say to a brokerage account or to a home, and that child gets sued for whatever reason. They have their own automobile accident, they're going through a divorce themselves, that can be utilized by that creditor or potential creditor, even though those assets were fully the parent's assets. So a potential creditor has a larger amount of assets they can now go after. So typically, I'm not a huge fan of adding a child. Now, if it's a $2,000 bank account, not so concerned. If it's a $50,000 bank account or a $100,000 bank account, then I'm definitely concerned. The other negative to that as well is if a parent adds a child to an asset, and if that child, as I said, is going through a divorce, that can be used in their divorce because that child is an owner on that asset, and that can be used in what they call an equitable settlement. So even though that wasn't the parent's intent, it may result in less assets going to their child. And the third and actually worst situation, and I've seen it unfortunately, is a parent adds a child to a bank account, a brokerage account, and so the child has legal rights to that. And I have seen a child clear out an account. Now, most people would say, well, that would never happen to me, and I agree. But when I've seen it, it's not a good situation. So typically in those circumstances, I'm just not a fan of adding a child, again, unless it's a very small amount. And the better way to do that is a couple things. One, if that parent has a general durable power of attorney, and let's say they name that child as their agent, that child can deal with that asset, and they have what's called a fiduciary obligation. So technically, they can't just take that money and use it to go on vacation. They have to use it for the parent's behalf. So the better way to get that same result would be to do what's called a pay on death or transfer on death account. So that account would still be in the name of the parent, and they still have full control and use over it. But if they, or when they pass away, it would then go to that child or that beneficiary, and it would avoid a probate situation. So it just really depends on a case-by-case basis. But as a general rule, I'm not a huge fan of adding a child to an account. Again, in some cases, if it's a minimal amount, not really a big issue. But if it's significant for all those reasons, I would not recommend adding a child to that.
Okay, Jonathan, as a follow-up, she said she does have joint assets with a parent, and then she was asking, what does she do upon their death?
Well, again, if it's a joint asset with a parent and that parent dies, now under the law, it goes to that surviving owner. So let's just say it was mom and daughter, and mom passes away. By law, it goes to the daughter. So there would not be any probate. So basically, that daughter could take a death certificate and say, remove mom's name off that account. And that surviving child has full access and full ownership. I mean, that's the true answer, is they now have full ownership of that asset.
Okay.
Okay. But again, under certain circumstances, I'm not a huge fan of doing that, but it just depends on a case-by-case basis. If you do have any specific questions that I've not answered for you, or you want to discuss anything in greater detail, I'm happy to discuss that. My information is on the website. I believe it's on the information here as well. So I'm happy to answer anything of that sort if you have anything in the future.
And also, so we are recording this. Usually it gets added to the city's YouTube account in a couple weeks. So for those of you who are watching, or for those who registered and weren't able to attend, I will send a recording. So you're able to, rewind, fast forward, do whatever you need to do.
And like I said, if something was not clear to you, feel free to reach out to me, and I definitely will try to explain it better if I have to.
Thank you. I feel like I always take copious notes during all of your presentations. So I do go back and I rewatch. So
Well, I appreciate that. Thank you.
yeah. All right. Do we have any more questions? Or I mean, I don't know. It's like gave us a lot to think about. So
Right. Yeah. You definitely want to do some planning. And really before either of those situations, death or divorce.
Yeah, definitely. Okay, well, thank you for your time. And yeah, I really appreciate it. And I'll make sure to send out the Bloom Advisors link with the link to the video in 2 weeks.
I appreciate that. And I appreciate you having me tonight. It was quite an honor.
Thank you so much.
Thank
you have a great night, everybody.
Take care.
Bye.
Bye-bye.